Good morning and welcome to the East Brandywine Township Board of Supervisors work session for Thursday, November 7th, 2019. Just a reminder, a recording device will be used during this meeting, and I'm going to open it up right now to public comment for non-agenda items. A reminder that rules for conduct of public meetings established by Resolution 2001-08. The time allotted to each individual making a comment shall be 3 minutes unless otherwise set by the presiding officer. Additional public comment may be granted at the discretion of the presiding officer at the conclusion of the meeting. So I'll open it up right at this time for public comment for non-agenda items. Seeing none, we're going to move on to the meeting minutes for the previous meeting, Planning Commission, October 2nd, 2019.
Motion they be approved as submitted.
I'll second. All in favor?
Aye.
Aye. I'm going to turn it over to Luke Revin, our Assistant Manager, for the Waste Hauler Collection Day update and the trash cart prices.
Good morning, Mr. Chairman, members of the board. I think we can put this old business item, agenda item to bed at the conclusion of the meeting here. We're joined in the audience by representatives of A.J. Blazinski, the low bidder who the contract was awarded to. We have some follow-up on the suggested or their preferred collection date. It is Tuesday, which is the same date we had 5 years ago. And correct me if I'm wrong, the makeup is always Wednesday? Okay. Also, later in your agenda, there is a presentation or just a brief introduction to the draft preliminary budget. That preliminary budget does not envision the purchase of trash carts for delivery in January of 2020. So I think those two items we can now put to bed. There is one other outstanding item, and that is the notification of the residents of the new date. There is a draft of our newsletter that includes this, and it will be in homes in mid-November. I apologize for putting you on the spot in this case. Would you, since you're contractually bound to notify all the residents of the new addresses, would it be your preference to have an individual mailing or to help support the newsletter mailing that indicates the change in? Thank you, and I apologize for not giving you a heads up on that.
Jim Clark from A.J. Blazinski. Yeah, we would have no problem, Luke, assisting in the mailing of the newsletter since we're requesting the change from Thursday to Tuesday. And we appreciate the opportunity to let us do that.
Okay, great.
I wasn't aware of that, Jim, so pardon me for the misunderstanding.
No problem, Scott.
All right. So I think we're set for January.
I think the other thing was you had indicated in the email that they're going to make a pickup that first week of January, even though the contract doesn't require it until the second week. Is that correct?
That's the idea, that we're going to do that first collection. I mean, if it's a draft letter at this point right now, if we have the opportunity, could we just have one more day to solidify that, because we may be able to pick it up that Tuesday? But I can let you know by the end of the day if it's not to the printer yet.
It's not.
If we're going to switch it to the first.
Yeah, it's not at the printers, and so that Tuesday would be December 31st?
That's correct, yes.
Okay.
So we would collect it, on the 31st, which is Tuesday.
Well, that would certainly be easier from a messaging perspective. If we're going to get residents in the habit of expecting trash collection on Tuesdays, it'd be great if the first collection was on a Tuesday. Yeah. Well,
And thank you very much for doing that.
Okay, no problem. Thank you.
I do appreciate that.
The only other thing with the trash, with the carts, Luke, I wanted to point out to you is I recently spoke to somebody in a different municipality who ran through a similar situation where Republic had dropped carts off, and then the contract changed and they left the carts. And I know we have a letter or an email from Republic saying that they're just leaving the carts behind. But this particular individual indicated to me that halfway through the year, they got a bill from Republic for the cart that was left behind. So I think we just have to be alert that if any residents get billed for Republic carts, that they shouldn't have to pay for them. So maybe when you put the announcement in the newsletter, you want to make a notation to that effect, so that people are aware if they get billed by Republic to let us know so we can take steps immediately.
Hey, Luke, on that point, can you guys remind me, was that, I think it was at your last meeting, the gentleman orally committed to that, or was it in writing that they committed to that?
Well, so we're talking about the incumbent hauler. This is Republic Services. He has never been at a Board of Supervisors meeting and made that oral representation. I do have a string of emails where he indicated that he is going to, or Republic Services is going to leave the carts that they delivered to homeowners.
Okay,
Well, perhaps we should.
okay, as long as there's something in writing, I think that's good.
But I think maybe we need to respond, Luke needs to respond to that email to say, our understanding is that you're leaving them and that the residents are not going to be billed for the cost of the carts, or something to that effect, so it's clear.
All right.
Yeah, I can do that. I would mention, for just the sake of clarity, the draft newsletter article does not mention the Republic branded carts. And I hesitated to bring that up in a mailing that goes to every homeowner for a couple of reasons. One is not every homeowner was given a free cart by Republic Services. And so I think if we were to say, hey, your Republic cart's going to remain beginning in January, you'd get a fair number of people who said, what Republic cart?
I think it depends on how it's worded, Luke, but I think it's important that residents that have Republic cards know that they're not going to have to pay for them, because 6 months from now, if Republic sends bills out to them, some people may just pay it because they don't know any better. So I think it's a question of, if you have a Republic cart, Republic has indicated that they're leaving it behind and you're free to continue using it.
Okay, you have exactly the same instinct as our newsletter editor, Diane Sweeney, and I pushed back, and I think I'm clearly losing that argument. So that we will make a reference to those individuals that have Republic cards in the newsletter article.
Okay, thank you. And going right back to you, Luke, for the secretary hiring update.
Yeah, well, that has been far more successful than I would have anticipated. At this point, we've received over 350 applications for our advertised position. Your packet includes 6 that I've selected as individuals I would like to interview. The action item this morning is to inquire of the board what kind of interview team you would like to build for selecting candidates. And I'd also say that I have no objection to any member of the board wanting to look at the entire universe of received applications, although 350 is a lot to read through, but you're certainly welcome to second guess my judgment relative to the 6 I picked. So I think as far as a staff team for interviews, I think it should include myself as this person's immediate supervisor. I think it should include Scott as the township manager, or any members of the board interested in participating in the interview process.
What did we do in the past? I think you guys did the initial, and then we sat down.
No, the initial was done by, well, in this case, Luke, and he's chosen 6 candidates to interview. And the last time, it was, well, 3 board members, Luke and myself.
Yeah, I don't have a problem with doing it the same way we've done in the past. And maybe not all 3 will be able to attend anyway, so.
Okay, is there a day next week where the 3 of you have some shared availability?
I'm assuming we're going to try to set them up some morning and do them.
I would like to do them
Consecutive.
all, yes, exactly, back to back.
I'm pretty flexible, middle to the end of the week.
Okay, how about the 13th, Wednesday?
Or do you want to start at like 8?
What's that?
You want to start at 8?
Yeah, and just line them up in, yeah, half-hour increments, and we'll get done in 3 hours. Supervisor Winters, are you available to participate on Wednesday, the 13th?
I'd have to check.
Okay.
Sure, I could be.
All right, I'll hold off arranging invitations until everybody can check their calendars. I guess I apologize for the ambush question in a public meeting. I will attempt to pick a date, and we'll have an interview team of all of the supervisors that can make it, and Scott and myself.
Yeah, I think you got to give them a little bit of a heads up too, because obviously some of these people are employed right now coming.
Correct. All right, thank you.
Okay, moving on, we're going to turn it over to Beth Euler for the municipal separate storm sewer system MS4 permit update.
Thank you. I don't know if I just, sorry.
Scott's got the controller here. Let me.
You do is tell me which one to do.
All right.
There we go. Okay. My name's Beth Euler with Cedarville Engineering Group. I've been working with the Township's NPDS MS4 program for the last several years, mainly with Matthew Van Loo, the Township Roadmaster. He's kind of been the internal contact from the Township for the municipal separate storm sewer permit. This is just to provide the board and the public with an update on the program itself. Wanted to just throw up a list of acronyms in case I slip and don't say something full, and maybe you can reference this going back. But the program is the National Pollutant Discharge Elimination System Permit Program. It regulates stormwater discharges. This is the municipal separate storm sewer system, so not every municipality in the state has a permit, but it's based off of population density by the U.S. Census Bureau. So you have to meet certain criteria in order to be a permitted entity, mainly having urbanized area within your boundary. The permit has a series of minimum control measures that have been implemented since the beginning of the permit program, which was 2003. And under those minimum control measures, the township's required to implement best management practices. The most recent permit has introduced some additional requirements, and those are the total maximum daily load, pollutant control measures, and in East Brandywine's case, the only thing that you are concerned with currently is the pollutant reduction plan. This is the unfunded mandate coming down from the federal government and administered by the Department of Environmental Protection in the state. So to give you a little bit of update, I'm not gonna go through each individual requirements of the minimum control measures, but just a little update on what has occurred in the previous year in terms of township activities, and what to anticipate moving forward as well. So public education outreach is minimum control measure number 1. In 2019, the township has, from our perspective, met the minimum requirements by participating in the Christina Watersheds Municipal Partnership. They place a newspaper ad in the Daily Local News, maintaining the stormwater website, and also publishing stormwater articles in the mile marker. Next year would be that it's time to update the written program associated with this minimum control measure. Along with that is updating the target audience list, which is a requirement of the permit, and then continue this type of outreach. The second minimum control measure is public involvement and participation. This requires a public meeting presentation on the municipal separate storm sewer system program, and that would be this meeting. And that would be reported in your annual report to DEP each year. It's things like making sure you adhere to the proper public notice procedures, which were accomplished with the pollutant reduction plan this past year, as well as community involvement. So next year, we're going to be looking towards updating the written program, conducting another public meeting. One is required every 5 years. However, we recommend that you do it every year to make sure that everyone is on the same page with where you are with your program. And then continuing involvement with outside watershed organizations like Brandywine Red Clay Alliance, the group that they organized in the Christina Watershed, which is the Christina Watershed's municipal partnership, and then being a liaison between the residents and organizations like Brandywine Conservancy. Illicit discharge detection and elimination. This is really important. This is your mapping, and this is really the basis of the program. So where your stormwater is discharging into the surface waters and has a potential to cause pollution to surface waters, there are certain requirements that the township has to monitor mainly once every 5 years, checking these outfalls and making sure that your mapping every year is up to date with new infrastructure that the township owns. Last year, we have conducted 62 outfall screenings, which is about 48% of the township's outfalls. This year, we're looking to do the remainder of the outfalls and also assess priority outfalls, which is a requirement of the permit. Those outfalls may have different screening frequency requirements, as well as updating the written program associated with this as well. So your ordinance is the one that regulates this minimum control measure, defining what an illicit discharge is or what it isn't, and basically it's anything that isn't stormwater that shouldn't, that going into your municipal separate storm sewer system, with a few exceptions that are cited in the ordinance. This is an example of your township web map app. Should play, looks like, I don't know if it's going to. All right. We always have technical difficulties with these maps playing sometimes, but this is an interactive web map app. Oh, there we go.
You owe me.
Thanks, you did that? Okay, great. Well, maybe it's not gonna work still. I don't know. There's something with technology, sometimes it just doesn't wanna go. But,
It's loading.
it's loading. All right, well, either way, instead of giving the township a PDF map that's static, this is basically the same deliverable, but it's an online interactive map, and that's how we're maintaining the township storm sewer mapping. I'll just move forward because I don't think it's gonna.
Well, it's about halfway. Give it a couple seconds.
How long is this video?
It
All right,
is-
let's just see if it go. I don't think it's actually working. I think it's playing right now, and for some reason the visuals just
I agree. That's
not coming
probably what's
through.
happening, and it's QuickTime. Are you an Apple user?
It's whatever you use to record in PowerPoint. So I'm
yeah.
not a technological expert
I
like
probably
yourself.
would need to install something on the presentation PC in order to play that video, so I don't think it's going to happen.
Gotcha. All right.
Thank you.
Well, I know that sometimes those videos don't play nicely with whatever broadcast technology you have. But imagine that you were zooming in and out and clicking things, and it is a functioning web map application. Construction site runoff control is minimum control measure number 4, and largely this is just the checkbox that you're agreeing with the statewide program for MPDS permits for stormwater discharges associating with construction activities administered by DEP and the County Conservation District. There are relatively minimal requirements under this MCM regarding specifically to the township. Post-construction stormwater management and new and redevelopment, what's really, I guess, not new, but moving towards implementation, is that the township is required to have an inventory of all best management practices that have been installed as part of NPDS permits for construction activities that were authorized since March 10th, 2003 and on. And we have that inventory, and now the goal is to ensure that they're being properly operated and maintained through the enforcement of the township's ordinance. So this past year, we did 35 inspections of BMPs, which at the time was 100% of the inventory. Part of that was also sending out some correspondence and education to those residents so that they understand that they have stormwater best management practices on their property that require certain operations and maintenance. In 2020, we've updated the inventory based on some nuances in the new permit language that and require on-lot seepage beds to be included in that, which is why the number went from 35 to 94. And we'll be looking to conduct inspections of those best management practices as well and then developing a compliance program associated with that. And then minimum control measure 6 is your employee training and pollution prevention and good housekeeping. So this is everything that the Public Works Department is already doing. It's ensuring that it's being documented in case DEP comes for an inspection or EPA comes for an audit. The township staff attended a multi-municipal training that we held this year. That counts towards the employee training goals. We also report in your annual report when township staff attend outside stormwater trainings. And then, for example, Matthew Van Lewis presented at some stormwater events as well. So we'll report that. Moving forward, the pollutant reduction plan is really your big ticket item here. And the biggest change, and we've kind of presented an update of this continually throughout the last several years. Culbertson Run is impaired for sediment, and unnamed tributary to Beaver Creek is also impaired for sediment, so that is where your requirements lie for your pollutant reduction plan, which means you have to reduce sediment to these streams by 10% over a 5-year period of time. The proposed BMPs are Hawthorne Drive stormwater improvements, which are restoring vegetated swales within the right-of-way and then installing 3 underground basins under the township road. Where we are right now with that is we're wrapping up some individual consent to enter agreements for temporary disturbance to private property for construction. And there may be some redesign for some private property owners that we haven't been able to get consent to enters from, which would be minimal. And then we anticipate going to construction in spring 2020. Again, we also received the Growing Greener grant for the construction of this project in June, which will be a significant help to the township in the amount of, it's close to $250,000. And then Culbertson Run Stream Restoration is the other BMP that's proposed right now. It's a 425 linear foot section of stream restoration. The property owner is the Hideaway Farms Homeowners Association. We presented information to the HOA at the board meeting on July 25th. They gave us verbal approval to proceed with feasibility study. We sent them more formal paperwork to just conduct the site assessment, and we're still pending site access right now from the homeowners association. We also have a funding strategy in place for the implementation, in progress for the implementation of this project. So the overall implementation schedule, it looks like the permit itself has been issued. Not many people or municipalities within Chester County have received their permit approval yet, especially when it's associated with the pollutant reduction plan. I believe that was issued back in August. And this is the preliminary schedule or the current schedule that we're looking at for implementation and meeting these goals. Stream restoration can take a long period of time, so applying for funding in 1 year, that could be delayed, and looking for funding a second year, which happened with the Hawthorne Drive project, and we did end up receiving funding the second time around on that. So this is just a summary of what to expect in 2020. Looking back through the minimum control measures and the pollutant reduction plans, most of these things are ongoing requirements of the permit, and will be ongoing requirements of the permit. Beyond 2020, it's much of the same. The one thing I do want to point out is that there are stormwater ordinance updates, which you may be aware of. They'll be coordinated with Act 167 updates through the Chester County Water Resources Authority, but they'll need to be adopted by September 30th, 2022. And that's pretty much what we're looking at right now as far as this permit cycle. If anybody has any questions.
Anybody? The 2 projects you outlined will satisfy our pollution reduction goals for
The 5-year permit period.
5-year permit period. Okay, good.
Correct.
And then is the 2 that we chose, one looks like it's around new construction, a lot of a newer development, and the other one looks like it's farther away. Was it chosen one harder one easier one, or are they both
Well, I think the
For
first.
sediment, I meant.
Yeah, the first one, the Hawthorne Drive project was chosen because there were concerns with the just stormwater drainage throughout that development. You know, there was erosion and impact to the roadway because of the fact that there was ongoing drainage issues, and that's because it is an older development. The newer development, that really is just a stream restoration project, and that stream restoration is just, the need for that is based on the historic land use of the area. And mill race, there's a mill right downstream there. So that area's been impacted by that. And so there's a ton of legacy sediments that's built up in that area, which is just what's causing the erosion and makes it a great candidate for a stream restoration project.
Okay, thank you.
Yep.
So
thank
we're
you.
now we're going to turn it over to the Brandywine Conservancy for their sustainable community assessment.
Thank you. We have a PowerPoint too.
Okay.
Sorry.
I'm working on it.
Thank you.
If you guys want to start by introducing yourselves, and then he'll pull that out, and we'll
Great.
go from there.
Sure. Hi, I'm Meredith Mayer from the Brandywine Conservancy. And we're here today to talk to you about our sustainable community assessment that we met with your zoning ordinance review committee task force. Was that last month? Last month about. This is not our PowerPoint. Oh. Yeah. Oh, thank you. This is, no,
That is not the PowerPoint.
no, sorry. Thank you. And this is a tool that we use, and today we'd like to give you a quick overview.
Just to lead up to this a little bit more,
you
the
find it?
township is planning to update its comprehensive plan, and so the Brandywine Conservancy was contacted to explain to the township, its zoning task force, our sustainable communities assessment as a tool to begin the comprehensive plan update. And Meredith's going to talk in more detail about our sustainable communities assessment. But from this assessment, the township can frame the comprehensive plan update based on some of the issue areas that are included in the assessment. So we're here today just to present this idea to the Board of Supervisors as a component of the larger comprehensive plan, which the township, I believe, hopes to get underway sometime in 2020. So.
All right, I think we're up now.
Yep, thank you, Scott. So when we talk about sustainability, this is a word that's really gotten greenwashed, as you could say, but we're really talking about the three legs of sustainability. So economy, environment, and society. As a land conservation organization, Brandywine Conservancy is mostly concerned with environment, but we believe that all three aspects are important, and it's really important to balance all three. Just to give you a little bit of background about why it's legal and important for a municipality to work on issues of sustainability, it's supported both in the Constitution of Pennsylvania and in the municipality's planning code. You may not think that your community can do too much to help with sustainability, but while sustainability is not only great for the environment, it can really help your community in a number of ways, both in protecting your resources, preserving your character, and can also help you save money. So getting down to the nuts and bolts of our assessment, what it does is we look at all of your adopted plans, policies, and ordinances, and we look for where there may be obstacles, where incentives can be created, and where standards can be enacted. And we draft a report of these findings and recommendations, We meet with you all to review and comment on the report, and then we revise it and release it. And as John said, this is a tool that can be used to help you frame some issues that are important for your comprehensive plan update, that you can use your comprehensive plan update to further explore and plan for. So these are the facets of local sustainability that we consider in the analysis. So it's really your natural resources, your water quality and quantity. It's looking at energy conservation and renewable energy, which is directly something that you can cover as part of your comprehensive plan update. Food production, security, community health and safety. This is an example of what one of the analysis sections looks like, really at a summary level. So these are some of the elements that we consider on the left. And then on the right, you can see some of the strengths that may be considered and some of the opportunities that this municipality had to further improve its mobility and transportation. So we've worked so far with about 10 municipalities to complete this assessment. Some of them have done it right before the start of their comprehensive plan update, and others have just done it as a separate update or separate effort. In particular, Warwick Township in Lancaster County has been extremely successful with implementing local sustainability measures. They completed our assessment in 2009 and then really built upon it to influence how the municipality makes decisions regarding land use and restoration, so on and so forth, really, in their municipality. They were the first township in Pennsylvania to reach the platinum certification through Sustainable Pennsylvania Community Certification Program, which is an award that you can apply for. So they've really leveraged it to change decision-making and to improve the way that their township is developed and run. So these are some of the benefits of completing a sustainable community assessment. It could reduce your municipal spending on land maintenance. It can further help in your efforts to manage municipal stormwater. We can look at ways to promote renewable energy opportunities. And lastly, as we've said a few times, identify issues for a comprehensive plan update focus. So it's a simple tool, but one that we hope can be enormously useful. So that's it. That was your 5-minute tour.
Thank you.
Do you have any questions, or is there anything we can kind of further explain? I know that was extremely quick, but we didn't want to take up too much of your time.
I will say that at the ordinance task force, when John and Meredith provided this, this is a precursor to their meeting with David Sweet to discuss how to go about implementing this review of our land use ordinances and tie that into a grant application to the Chester County Planning Commission's Vision Partnership Program, or grant program, which I believe you're meeting next week with David, right?
Yes, correct.
And then that will tie in with the comprehensive plan update that we've discussed at the task force, because it is, the comp plan was last revised in 2009. So it's time to take a look at what further revisions are necessary, and this would be part of that.
And I would say that at the task force, we also had a discussion about the cost of having the Conservancy do this, and I was pleased that the cost, I thought, was relatively modest and would provide us with a big leg up in terms of kicking off that comprehensive plan review. So I thought it was a very worthwhile investment in order to get us on the right track for the comprehensive plan, which is, having gone through that before, it's always sort of cumbersome and difficult.
Any other questions? Thank you.
Great, thank you much.
Thank you both.
Okay, I'm going to turn it over to Chief now for the request to amend medical reimbursement for the police lieutenant.
Good morning. As the board's aware, the board has a amendment agreement with Lieutenant Yankanich in his contract for a medical reimbursement to equal the amount he pays into his wife's medical plan in lieu of taking the township's medical coverage. In 2019, that amount was $824 per month. In the agreement, if that amount were to change, the lieutenant has 7 days to notify the township, which he has done, and it is the sole discretion of the board to modify the payment. The lieutenant's notified us that the payment is increasing to $897, and that would be the monthly payment that equals what he needs to pay to maintain coverage under his wife's plan, and it is still a savings to the township of about $15,000. So I would just ask the board to consider approving an increase in the monthly reimbursement to begin on January 1st, 2020, of $897 per month.
So moved.
All in favor?
Aye.
Thank you.
Thank you. I'm going to turn it over to Kristen now. Hopefully she can hear us for the Carlino developer agreements.
Yep, I can. Can you hear me?
Yep.
Okay. So as you know, the board approved the final plans for the Carlino development. I think Mr. Kaplan is in the audience with his client, so if he needs to jump in, he can answer questions. But as a result of that final plan approval, obviously there were many conditions that had to be met. There were revisions to the plan that were needed. Those revisions have been submitted to Nate Klein and Andy Heinreich. Both Nate and Andy sent correspondence last week, which is sort of what I was waiting for, before we would move forward with any legal agreements that are needed, either based on conditions of plan approval or ordinance requirements in terms of posting financial security for the public and quasi-public improvements. So there's a series of legal agreements that need to be approved by the board. A lot of these are, and I'll go through each one and summarize them at a high level. A lot of these are standard agreements that you see with every development, obviously tweaked and tailored to be specific to this particular development. And then there are also some that are specific and not the run-of-the-mill agreements and specific to this particular development. So I'm going to go through them. There's no set order that I'm going to go through them. We'll start with a traffic signal easement. So this is as a result of the connector road being constructed and a new traffic signal being constructed at the intersection of the connector road and Route 322. Any traffic signal within the township is ultimately owned by the township. There are PennDOT permits that are needed. Traffic signal permit plans have been submitted. Andy Heinreich has reviewed this. And the land area where the traffic signal will be located, the developer is offering an easement to the township. This document, again, is pretty straightforward. It's just offering an area of land to the township to be able to own and maintain the traffic signal. The installation of the traffic signal is taken care of by the developer. This agreement would not be, although I would I would like you to be able to approve the chairman signing these documents. This document would actually not be recorded until the land development plans are recorded and until PennDOT has issued its final approval of the traffic signal permit plans. So again, it's just an easement being granted by the property owner, and they're also not the property owner yet. So they would need to go to settlement so that Carlino East Brandywine LP, who's identified as the grantor, they have to actually be the property owner before this document could be recorded in the Recorder of Deeds. But again, as far as form and substance, there's a plan attached that shows you the area of the easement. There's a meets and bounds. All of this has been reviewed by both Andy Heinreich as well as Nate Klein. Are there any questions on this document?
I have none.
No.
The next one is something that's specific to their plan. If you recall, within the parking lot, there are areas of porous pavement, and that came out in Nate Klein's review of the plans that your ordinance does allow porous pavement. Nate brought up a concern about making sure that it remains porous, and one of the conditions that was imposed on the approval was they had to record a covenant in terms of, that would identify exactly how the porous pavement had to be maintained. Again, this was something I relied heavily upon Nate Klein to provide his comment, to make sure that the proper maintenance regime is put into place. This document is recorded in the chain of title, so whoever owns this property is obligated to maintain the porous pavement in accordance with the routine and the schedule that's identified within the document. The exhibit to the document identifies the areas of the parking lot where the porous pavement is proposed to be installed. There are, and I will say that for these agreements, Mr. Kaplan circulated the original drafts, and then I, edited them. I met with Nate and Megan from Pannoni's office, and I had, them provide comments and, added my own enforcement mechanisms that I thought were important to make sure that the township was always protected and that we had appropriate enforcement mechanisms in the event that the property owner did not properly maintain the porous pavement. Any questions on this document?
No, did I hear you, this is going to be a deed restriction?
Yeah, I mean, when it's not in their actual deed, but this document is recorded against the chain of title to this property. So whoever owns this lot, for so long as the parking lot continues to have these areas of porous pavement, whoever is the owner is responsible to maintain it in accordance with the schedule that's listed in this document, yes.
And so that would turn up on a title search?
It would turn up on a title search, correct?
Okay.
It also, a lot of the language that's in this document, as far as specific things that have to be done to maintain the pavement, these are also notes on the plan. So this is sort of a belt and suspender. Oftentimes, when you get a title report, it references the land development plan, but they don't copy it because it's, it's a large plan. So a lot of times people buying the property, they'll have a title commitment that says, oh, you take title subject to the notes on the plan, but nobody bothers to go get sheet whatever it is of the plan that has the specific notes. So this document is much easier. It will get printed and record, as a title commitment, it'll come up, and then it'll have the specific notes that are spelled out in this document.
Understood.
Okay, I'll move on to the next one, is also something specific to this particular plan, and this came about as a result of your comments from your planning commission, and it's to promote connectivity in your trail system. So it's the pedestrian and bicycle easement agreement. One of the conditions of the plan approval required a trail connection from the Mapleview residential development into this shopping center. So there will be a 10-foot wide easement where the Mapleview easement, or the Mapleview Trail, I guess, connects up to this parcel. It'll then go across the front of the across the front of the shopping, the store, the giant store, and then it'll ultimately connect into the connector road. There was some communication about this. There was some concern, obviously, as a shopping center and cars, vehicular traffic. We split it apart into an area where the pedestrians would be guided to go and an area where the bicyclists would be permitted to go. Again, whether or not somebody is going to stay within the confines of that area is, that's not something that's easily enforceable, but if we needed to and it became a problem, we could turn back to the specific language of where the easements are provided and the map and the plan that's attached that show where the pedestrians would be going and where the bicyclists would be going. Any questions on this one?
No.
Okay. The next one is the deed, and this is a deed that has to be conveyed to PennDOT. And as far as timing, this is probably the most critical one. This is holding up the issuance of the HOP. PennDOT has alerted, and Mr. Kaplan, you can jump in if I incorrectly state this, but the way I understand it is that the review of the HOP is ongoing, and there's various submissions that are required. And PennDOT has told Carlino that they're not going to move the ball any further in terms of issuance of the HOP. This is one of the things that's needed. This is a deed that would be land area conveyed to PennDOT. the land area was part of the land that was condemned. When Mr. Kaplan had asked before that this document be presented to the board for approval, I was not comfortable doing that because we had not tendered the estimate of just compensation to the landowner. And under the eminent domain code, even though title passes upon filing the declaration of taking, and then in this case, when the preliminary objections were overruled and there was a final decision, the township is not entitled to possession of the land that's condemned until you tender the estimate of just compensation. So now that that's been done, the township has both ownership in terms of fee simple title as well as the right to possess the land that was condemned. And this is a small portion of that that has to ultimately, be conveyed over to PennDOT. And the area is, I'm looking at the plan, it's an area of, it's the 0.069 acres that was condemned for the connector road where it connects to Route 322. So again, this is a form that PennDOT requires, and it's again being signed by the township because now as the township condemned that land area, the township is the owner. Moving on, there are two agreements that are associated with the fact that there are stormwater management facilities that have to be constructed. The first one is just titled Stormwater Management Facilities Operation and Maintenance Agreement. This is a standard form that every development that is now required to do stormwater management is required to sign. This is actually an appendix to your stormwater ordinance. It was the form that the Act 167 ordinance, when the county adopted it, required townships to also utilize. Obviously, it's been tailored to be specific to this developer and this development. This is also recorded against the Carlino property in their chain of title. It requires them to maintain whatever BMPs are constructed on their property, and it has maintenance schedules and inspection rights of the township, and obviously enforcement rights of the township. Again, very standard. The second agreement that relates to stormwater management, I don't know if you've done one yet, but if there are stormwater management facilities that have to be constructed within PennDOT right-of-way, PennDOT probably 3 or 4 years ago took a new stance and issued a letter, or a policy letter, that basically said, township, you need to now be the permittee on these highway occupancy permits that are issued to allow stormwater facilities in a PennDOT right-of-way. And townships are saying, well, geez, why would we want to be, we have enough of our own stormwater systems, as Beth Euler, mentioned to you in her report. We'd like to be able to shift the responsibility for maintaining these new stormwater facilities to the private property owner who's developing the property and who necessitates the need for these facilities. So that's what this agreement does. It identifies that the township will be co-permittee on the HOP with PennDOT, but that ultimately it's the property owner that's responsible for the specific drainage improvements that are constructed along their property frontage within the PennDOT right-of-way. It mirrors the enforcement provisions in the other stormwater agreement I referenced, so that the township has the right, if they find out that the facilities are not being properly maintained, they can go back and rely upon the terms of this agreement to put the onus back on the property owner. This would also, again, all of these agreements, the recorded documents that have to be recorded against the chain of title, they cannot be recorded until Carlino goes to settlement and is the owner of the land, and they would be recorded, contemporaneously with recording of the final plans. The next two agreements are, again, standard for every development. The one is the financial security agreement, and the second is the development agreement. These documents have a lot of boilerplate language, but then are tailored to this specific circumstance. In this instance, the developer is not having they're planning on issuing a letter of credit for the public improvements. Nate Klein has reviewed the opinion of probable cost and issued a review letter, I think it was last week, but then he updated it this week, and identified the specific amount of financial security that must be posted. Carlino intends to post a letter of credit, and I have reviewed a draft of the letter of credit. They will not issue the original letter of credit until such time as they go to closing. That will be part, I'm assuming, of part of their construction loan, is that the bank will fund the letter of credit. The township will not release the plans for recording until such time as we have the original letter of credit in hand. Part of the financial security covers the cost to build the connector road. So that number has been vetted by your engineer. The total amount is identified on page 5 as $5,162,269.27. Something that is, I don't know if you've done this in the past, but we're requiring the developer to not include in that $5 million letter of credit the inspection costs, the estimated inspection costs. Instead, what we've proposed is that they have a $100,000 cash escrow at the township, and the township would use that to cover the cost of inspection. So if Pannoni's inspectors go out, as the public improvements, as the connector road's being constructed, at various stages of that construction, Pannoni would be called to go out and perform inspections. When Pannoni submits their invoices to the township to be paid, the township would have this $100,000 cash escrow to be used in the event the bills are not paid. It's a much easier as far as administrative work, because having the letter of credit is great, but if they fall behind in paying the fees, we don't want to have to go against the letter of credit and get the bank involved. It's just easier if we have that cash on hand. So that was something that is put into this agreement. The developer agreement has a lot of different language was added to this agreement to reflect the fact that there was a memorandum of understanding. What I tried to do was carry over from that memorandum any outstanding obligations of the developer that have not been met. For example, as I mentioned earlier, we have paid the estimate of just compensation to L&R Partnership, Mr. Cropper, and BBA. They have petitioned for a board review, and that will be scheduled probably within the next 6 months. When a board review ultimately determines whether or not they've been paid sufficient just compensation, depending on whether that's appealed or not, but at some point in time, there will be a final determination as to the amount of compensation. The memorandum of understanding obligates Carlino to make that final payment. I carried that over into the developer agreement because I want to make sure it's in everybody's mind and forefront and it's not forgotten as an obligation of the developer. Probably the most important part of the developer agreement identifies what conditions have to be met, and that's starting on page 10 under paragraph 4, conditions that must be met before the release of the plans for recording. So all of these, we reference the payment of the fee in lieu of open space that's owed. We reference all the different documents that I've gone through that have to be executed and in our possession so they can be recorded with the plans. We have the $100,000 I mentioned for the inspection fees. We have the actual letter of credit issued by the bank. When we have all of these, and not until we have all of those conditions met, would the township be able to release the plans and have them be recorded. So again, I appreciate Nate's assistance in helping me work through these agreements. Mr. Kaplan and I have been back and forth for several weeks now. We've been working on them, but I did not feel comfortable presenting them to you until we knew that the plans had been revised consistent with the order of June in this year. So again, happy to answer any questions on any of the agreements. I know it's a lot to digest. They have indicated that they intend to move forward, and Mr. Kaplan, you can again chime in on that, but they're working with their bank, intend to move forward and get all of go to settlement, get all these agreements executed before you. If you're comfortable with the terms of them, you could authorize the chairman to sign them when you're presented with the original versions from the developer.
Anybody have any questions?
I don't have any.
Yeah, I do. These same agreements were presented 2 years ago at the last supervisors meeting before 2018, and it was tabled until the new supervisor was sworn in for the next year. So I don't really, in my opinion, I'd like to extend the same courtesy to the next supervisor, Ken, considering that this plan is under appeal. It's not going to be decided before the new year. These agreements don't even have to be executed until the signing and recording of the final plan, so it's not like it's holding back anything, considering it's been 2 years since the last developer's agreement. So I think that, I know I would prefer to extend the same courtesy to Ken as you did for me, Kyle, to be able to have him included, as well as, you know, I just received these Monday, and I haven't even had a chance to review them yet. It's just a lot of papers, so that's kind of.
Yeah, I think that's a fair comment in terms of the review of the documents. It's a short turnaround time. I will tell you that a lot of them are standard agreements. As far as extending the courtesy to the new board member, that's completely up to your, this board. Although I will say that this is a little bit different than the situation back in 2018, in that back in 2018, there were still outstanding preliminary objections on the condemnation matter. This developer, the litigation has proceeded to the point where the only thing that's out there right now is an appeal of the land use decision. It is that they're proceeding at their own risk. So the township has there's no harm or no jeopardy for the township. It is the developer that is asking to proceed at this point in time. They have, I believe you have a legal obligation to let them move forward. They have satisfied the terms of the order as far as the conditions. I don't really think I think if you refuse to enter these agreements, they would have the ability to ask the court to force you to sign them, because they proceeded far enough along in their development and they've done what the order has required them to do.
Yep.
So it's a discretionary decision for the board. I'm not suggesting that that's not up to your discretion, but I am suggesting to you that it is the developer who's asking to push this forward at this time. They're the ones that want to proceed, and again, they'd be proceeding at their own risk in the event the court would overturn the appeal. But it is different in that now there is no appeal left. We know 100% that the township is the owner and that is able to possess the land that was condemned. There's nothing holding up the ability for this developer to move forward and construct the connector road, which that was an outstanding issue back in 2018.
Well, I think also part of the issue is, I believe the developer is not permitted to start until all lawsuits are final and unappealable, and as of right now.
No, that's not accurate. That is absolutely not accurate. First of all, the only lawsuit that's out there is an appeal of your decision, and they are able to proceed at their own risk. There's nothing that stops them.
But if
The appellants have not filed and requested a stay, and therefore there is no stay of the board's decision. So right now, the developer is able to proceed with the approval that it has, unless BVA or one of the appellants seeks a stay of the court. They have not done that.
But what is the harm if the whole entire plan's under appeal, so it's not going to be decided by the new year? Whether or not the developer wants to move it on at their own risk is not really, a concern to me. My concern is, being able to have some time to review these, half an inch thick of paper.
Well, you're saying two different things. So having time to review the documents, as I said, that makes perfect sense. I apologize that I didn't get them to you until Monday. There was a lot of moving parts, and I was still waiting for Nate to confirm some things before I sent them to you. So that I understand. If you're saying you want to wait until the new year, that's, again, a board decision. I don't think that's fair to do to the developer. The developer is telling you that they're ready to proceed. We've approved the plan. The township, the board approved the plan. The order approving the plan necessitates them to do and take certain steps and present to you certain agreements. They have done that. We, as the township, I do not believe we have the legal right, because obviously you did not file an appeal. The township board did not file an appeal of the decision. You supported the decision. The township board supported the decision. There's nothing from the court that issues a stay saying that they may not proceed with their development.
Is it going to
So
hurt
the
anything,
state of
though?
affairs right now allows this developer to proceed with their development as it's been approved by the township. So refusing to acknowledge and sign these documents would in effect be going against the order that was entered in June of 2019.
Well, I'm not refusing to sign them, Kristen. What I'm saying is I'd like to be able to understand them and actually have maybe a face-to-face conversation with our solicitor about it, As I said before, I'm more a visual person.
So-
But also, I mean, you know, I don't think that, I don't see how it would hurt anything to have a little bit more time to review them. And as far as the next year, the next board member will be dealing with this project. So I think I think that they should have some kind of input, or at least brought up to speed over everything, as I had. And, you know, I don't think that waiting is gonna be a big deal, but I also, in here, you have the order, but I'm confused because this order that's attached to developer's agreement is the order that was approved, but your firm had struck my affidavit stating the exact, that when I had said that, my affidavit to the court saying that there was never a 96-page document presented to the board, nor has it ever been available to view in the township building.
Jason, that's part of the litigation, so that's not
Kristen,
something that's
it's part of
appropriate
this
to attach
developer's
to this
agreement.
agreement.
It's attached
That's
to the
something the
developer's
court can
agreement.
decide whether you were right or wrong. It has nothing to do with the exhibit that should be attached to the agreement.
Kristen, it's attached to this agreement that you want us to sign. It's a valid question. So if that's the case, then why would you advise the board to strike a supervisor's affidavit stating exactly what you have here? It's a, conditions, numbered to 26, not, 96 pages. I'm still curious about that because that was never ratified in a public meeting, and I want to talk about it. And I think that all this stuff is being rushed like it was at the last minute back in 2017. And it says in all these agreements that this has to be done prior to the signing and recording of the final plans. So we're not in any rush, considering that oral arguments 12/19.
Well, Mr. Kaplan can speak to his client's desires in terms of timing, because I can't speak to that, so.
Oh, I know, but I'm talking about the desire of the board right now.
Well, you're one person. The other two board members can chime in what they're willing to do.
But what about
I think it would be helpful, Mr. Kaplan, if you could speak to what your client's desires are. I'm not the one pushing this. This is something that has been presented to me to present to you as a result of Carlino wanting to move forward.
But it'd be nice to have it more than 3 days before a meeting and where you explain.
Jason, I just explained to you. There's many documents here. There's been moving parts. I've received on Monday the final letters from Nate Klein. I'm not asking you to approve it this very day. I'm presenting them to you and giving you that option. You've already articulated you want additional time. I think that's fine. But what I'm saying is you made two different comments. You made one comment that you need additional time to review the documents, which is fair, absolutely. But then you made another comment that you don't even want the board to act until the new year because you want the new board member to participate.
Let me
Again,
interrupt real quick.
these are board decisions, but I'm saying that I think they're two different points you're making.
So let me interrupt real quick. So in fact, in 2017, yes, I will agree, it was at the very, very last meeting, and clearly no time for anybody to digest the documents. I would agree with Jason that people need to be able to, a couple of days to at least digest this.
Sure.
So my opinion, again, we're still in, well, not in October, we're beginning in November, but we're still, we have another meeting in November. I would think that we would certainly have the opportunity over the next couple weeks to digest this material. I don't personally have a problem with pushing this to the next meeting and giving Jason a time to digest this, and obviously, we all have to. But that being
Sure.
said, I'm going to turn, since Mr. Kaplan's standing at the podium now, I'll let him give his feedback.
Well, we want to move forward. Technically, your order sets a whole series of conditions. We've satisfied the conditions. In a manner of speaking, I think we're both required to sign this agreement. And I think there's a misunderstanding here. We are signing the development agreement, we're signing the financial security agreement to more spell out all of the obligations that were put on us in the order. When we close on the property, we will then be able to record the plans, and we will post the security. And all of those documents that Kristen talked about that will be in the chain of title will be recorded. But the framework of what goes on forward is in the development agreement and in the financial security agreement. And we don't want to start over with a new board. You gentlemen have been involved all along. The documents, when you read them, you will see reflect the things that we've talked about for years, the things that were required by the Planning Commission. We want to move on. We are talking to our bank about acquiring the funds to close on the ground and put up the security. The fact that there's an appeal does not prevent any of that. The law is very clear. The municipality's planning code is very clear that if the protestants, the appellants, want to stop us from going forward with the development, they've got to go to court and ask for a stay. That's not happened. We are willing to go forward, close on the ground, put up the security, and we think that these documents should be approved now or approved at your next meeting. When you read them, you'll see it's the synthesis of all of the things that we have talked about for an awful long time. So we ask that you approve them and sign them. If you move it over to the next meeting, that's fine. That's fine. But both Jay and Kyle have been involved in this forever. You know what the background is. The documents reflect all of the background. And be frank, we don't want to start with somebody new who's not familiar with it. We've seen what's happened since Jason's been involved. Everything's been a fight. We can't have that go on any longer. So we ask that you move this forward, and we'd like to get it signed this month. That's our position.
Well, I've made my opinion. I'm okay with, now, just, now's pretty much a good time as any to put everybody on notice that our next meeting, Board of Supervisors meeting, is going to move from Thursday the 21st to Tuesday the 19th at 7:30 p.m. So my personal stance is I'm okay with giving everybody the time to digest these documents and putting this on the agenda for the 19th. I'm one of three. I know Jason has a different opinion, and I'll let Jay make a decision.
I would agree to have it considered on the 19th.
Thank you.
All in favor?
And I would just say to the board, if you have specific questions or want to schedule a time for me to come meet with you individually, as a board, whatever, I'm happy to do that. We can walk through the agreements in whatever detail you want.
So do we make a motion on that, Kristen?
No motion's needed.
All right, and now we have some sad news for the resignation from an Open Space Committee member. I'll turn it over to Luke.
Yeah, just if you don't mind, a administrative point on the agenda item relative to the developer agreements. I'd like the board's permission to not reproduce all the same documents that are in your packet. Your total packet today is pushing about 375 pages. If I could have everyone perhaps consider bringing that element to the meeting next time rather than reproducing that.
Agreed.
Appreciate that. Thank you. Yes, I am sorry to report that Andrew Thurston, member of the Open Space Committee since October 26th, is pending a move to North Carolina. He will be resigning his position on the Open Space Committee. I want to extend my thank you to him for his service and willingness to volunteer. But I guess I would respectfully ask the board accept his resignation from the Open Space Committee.
So moved.
All in favor?
Aye.
Thank you.
All right, so now we're going to keep it with Luke again and going over the 2020 draft preliminary budget presentation.
Right, this isn't exactly a budget presentation. This is your sneak peek at the preliminary budget that will be on your agenda for November the 19th. The second-class township code requires that you adopt a preliminary budget 30 days before you, or it might be 20 days, some length of time prior to when you adopt a final budget. And in that interim, we need to advertise it. The Open Space Committee in our community is tasked with preparing a budget for the board's consideration. They've met 5 times, and what you have in front of you in your packet in the form of a line item budget and a selected detail of those line items is the work of their 5 meetings and a considerable investment in time and energy. They have heard from multiple committees and departments and even external service providers in coming up with this proposal. At the highest level, I would like to just kind of summarize the changes. For 2020, the Budget Committee is recommending that two programs that are currently in the general fund be removed to their own fund. Both of these programs have earmarked revenue sources, and I think best practices dictate that they be in their own fund. Those 2 revenue sources are our fire services tax and the fee for recycle and trash. So beginning in 2020, we would have 2 new funds for fire services and the solid waste program. The other, I guess, we'll call it 30,000-foot view perspective on this budget is, while it is balanced, the total revenues anticipated in 2020 are less than what you see as the total expenditures anticipated in 2020. And the reason I can say that is balanced with a straight face is because the second-class township code requires that municipalities plan for their expenditures with revenues available. So what would happen is that the fund balances would be drawn down, and the fund balance on January 1st plus the anticipated revenues is greater than the expected expenditures. Now, I think what the Budget Committee has done over their series of 5 meetings is hear all of these reports, and they have pared down, to the best of their ability, these requests to what they think is appropriate to recommend to the Board of Supervisors. There were 2 assumptions made in those 2 new funds. Because those new funds no longer have the capacity to be subsidized by other revenues in the general fund, the Budget Committee is recommending increases in the associated fees. So let's start with the solid waste program. We just entered into an agreement with A.J. Blazinski. This agreement, for the first time, separated the tipping fees associated with recycling from the labor of the hauling contract. And in addition to that, the hauling contract, just the labor for curbside collection and transportation to the tipping facilities of our choice, increased by 40%. The majority of the increase in the costs associated with the solid waste program are related to the recycle program. So you should be aware that the budget anticipates an increase in the trash and recycling fees. In 2019, those fees were $65 a year for trash and $70 for recycle. The Budget Committee is recommending that the recycle fee be increased to $85, so $15 per year per household on the recycle fees in order to make that new independent fund balance. The second new fund, where the Budget Committee is recommending an adjustment to the millage, is the fire services tax. The fire services, there's multiple expenditures in that account. Among them are workers' comp, cash contributions to the fire company fuel, and also the fees we pay for hydrants in the community. There's also several revenue items, the largest of which is a dedicated portion of the millage for fire service purposes. Also, we receive funds from other municipalities to offset our liability for workers' compensation, and we have a pass-through for firemen's relief. In order to make all those line items balance in the first year, and as I mentioned, it's no longer possible to subsidize from the general fund, the Budget Committee is recommending an increase in the millage from 0.365 to 0.420. The Budget Committee made no recommendation relative to the general fund itself. I mentioned that the anticipated revenues are larger than, or less than the anticipated expenditures. The Budget Committee proposes to the board 3 general options for dealing with this. You know, they felt that it was above their pay grade, so to speak, to make a recommendation on how to deal with that deficit. The first of which is the operating revenue represented by the beginning and end balances in the general fund be used until the natural growth in township revenues catch up with the deficit. I think, you know, the perspective here is that as a growing community, our revenues increase linearly and somewhat predictably. It's a straight line as new houses come online and new residents move to the community. The difficulty that the Budget Committee and administration face is that trying to right-size our staff to respond to these increased demands is not linear. If you have 3 people and you add a 4th person, the cost does not go up 3%. As revenues does, your cost went up 25% because you just added another person, or 33%. Just to illustrate the point that while revenues can be linear, our largest expenditure, which is labor, is not linear, especially as a small organization. It's very hard to scale that. The second option that the Budget Committee proposes to the board is to increase the millage in real estate for general township purposes to 2.752. What I've got in parentheses in my memo is actually a typo. For general purposes, the current millage is 2.5. No, that's correct. That's the increase. So I'm confusing myself. The current millage for general township purposes is 2.5. The recommendation, or one of the options for the board action to create a balanced budget where revenues and expenditures are equal in the coming year, is to increase that millage to 2.752. Your third option is any combination of using the balance in the capital and in the general fund and increasing taxes. I don't know that I did a good job summarizing those 3. Mercifully, there is a memo from me that does not include my stuttering that you can review for a little bit more clarity. There is no action required of the board today. This is your sneak peek. The Budget Committee has advertised one additional meeting, and that would be a week from today. Right now, they're not planning on meeting. But if the board would like them to examine some portion of the draft budget in front of you, I would like to know by, say, Monday of next week so that we can use that already advertised meeting date and respond to any concerns that the board has relative to the budget. Are there any questions on what's in front of you?
I think I have just a couple of questions. A couple of these items went up 30 to 50, even 100%. And I guess I can probably put mine in writing and try and figure out how that's accounted for, but I mean, here's one for 390%. So I guess we'll have to, I'll go through it and get my questions asked. And I guess everybody has an opportunity to do the same.
Right, for the purpose of navigating the record, I would draw your attention to the far right column on that general fund. There is a series of yeses and nos that reference the detail form. If the line item you have a question about has a yes next to it, it means that in this detail form, there's actually going to be a breakdown of the expenses.
All right, what if it has nothing?
If it has nothing, then it was assumed by me that the name of the line item was sufficiently descriptive to see what that expenditure was. So for example, if the line item is Luke's salary, it isn't really necessary for me to have a detail that says, this is Luke's salary.
Got it.
Now, that said, I can understand that some certain things like insurance or something needs a further breakdown on what you mean when you say insurance. So,
Okay. Anybody have any questions?
I don't have any questions, but I just want to make a comment. As you, I think you gentlemen are aware that the Budget Committee did invite us to attend the last two meetings, and I had an opportunity to attend one of those meetings. And I think we are extraordinarily fortunate to have such a wonderful group of people who are willing to do what is really grunt work on this budget. And I was very impressed with their knowledge of our expenses and our revenues, the questions that they asked. I asked a few questions at that meeting. They were able to respond immediately. And I think everybody that's on that committee contributed, but I want to call out in particular the contributions of Carl Croft, because his background as a CPA, his experience with the school district doing budgeting was very evident in that meeting and the discussions that we had. And I think we're very fortunate to have his voluntary contribution to the Budget Committee.
I second that. Thank you.
Luke, can you just speak, though, to what you are going to be asking the board and the timeframes given the advertising requirements in the event that the millage increases? I just need to make sure that's in their minds as to when the ultimate decision has to be made.
Right. In order to allow Kristen and myself enough time to advertise tax or fee increases and to advertise the preliminary budget as available for public review in the township office, we will need a decision on tax levies and adopting a preliminary budget at your November 19th meeting.
And Luke did have that in a memo, Kristen, at the very end,
Okay. Okay.
in bold.
Yeah, unlike most advertising requirements, if you increase the millage, the Local Tax Enabling Act requires 3 consecutive weeks of advertisement. So that's, given the timeframes of your meeting, sometimes that's difficult to meet.
And I think that's why the decision was made to move that meeting up that week rather than postponing it to the following week.
Okay, thank you. Do we have any zoning applications today?
No,
Okay, ordinance task force updates?
none.
And no,
Other than November 20th is the next task force meeting.
okay. And then no resolutions for consideration. Do we have any public comment on agenda items? Seeing none, we'll move on to notices and executive session of the Board of Supervisors. Follow the October 17, 2019 regular session for the purpose of, 1, considering the purchase of real property, and 2, to discuss personnel matters. An executive session will be held following this meeting for the purpose of considering the purchase of real property. And I would also like to remind everybody the new meeting for the Board of Supervisors will be 11/19 at 7:30 PM, canceling out the 11/21 meeting. Do I have a motion to adjourn?
So moved.
All in favor?
Aye.
Aye.